we shall continue. Let me invite everyone to the stage. You can join me later, and I shall announce the participants of our first panel discussion. Let me switch to English.
So the first panel discussion, the modality of the Tribunal, UN, International Treaty, hybrid format, which one to choose? The moderator, Andrii Smyrnov, Deputy Head of the Office of the President of Ukraine, and we will welcome at this stage Stanislav Kravchenko, Chief Justice of the Supreme Court. Прошу, ваші оплески. We will welcome at this stage Aarif Abraham, barrister, writer and speaker specializing in public international law, international criminal law and human rights. Also, Jordash, President of Global Rights Compliance, lead of the Mobile Justice Teams supporting Ukraine OPG, Deputy of ASA. Також we are welcoming Jörg Polakiewicz, Director of Legal Advice and Public International Law, Council of Europe. And we will have at this stage Oleksandra Matviychuk, Head of the Center for Civil Liberties, Nobel Peace Prize Winner 2022. It seems to me that we are almost ready. Ну що ж, друзі, з вашою допомогою.
Okay, so let us give a round of applause to our speakers. And we'll have a number of online participants as well. Rain Thompson,
Republic of Estonia to the United Nations will join us online. Also online will join us Richard Goldstone, South African former judge, first chief prosecutor of the United Nations International Criminal Tribunals for the former Yugoslavia and for Rwanda. Also, there will be Klaus Kress, Professor of International Law and Criminal Law, Chair for German and International Criminal Law, and Director of the Institute of International Peace and Security Law at the University of Cologne. We will welcome online Philippe Sands, British and French writer and lawyer, Professor of Laws and Director of the Center of International Courts and Tribunals at University College London. And also we will welcome online Franco Marcelo Fiumara, lawyer, criminal court judge, Argentina, criminal procedure professor in Law School of La Matanza University. Отже, від мене наразі все. Андрію, the floor is totally yours, тож прошу, передаю вам мікрофон.
Sound check. So, we shall be starting with our panel discussion. We've already introduced our guests. Special thanks to our international friends who managed to arrive to Ukraine despite the security risks. I thank to those joining us online, and the first discussion is all around the model for the operation of the Special Tribunal. We understand that if Ukraine would ratify the Roman Statute, it would be much easier. And it would be even much easier if Russia would ratify the Roman Statute, because that, in this case, will be able to hold them accountable for the crime of aggression. Now, if we raise the political issue of ratifying the Roman Statute, this is, well, we clearly understand that Russia will not do that, will not ratify the Roman Statute. So for 70 years, the crime of aggression was not punishable. And that is why Russia managed to commit the aggression in Russian Crimea, in Ukrainian Crimea, in Ukrainian Donbass, and then they committed a crime of aggression in Georgia. And we can see crimes of aggression in many continents, and the inability of the world to start an effective mechanism for the responsibility of the crime of aggression. It legitimizes such criminal actions in minds of certain dictators. In the beginning, I would like to pass the floor to the head of the Supreme Court of Ukraine, Mr. Kravchenko. So could you please share your thoughts on the effective operation of the special tribunal? First, on behalf of all the Ukrainian judges, I'd like to welcome you at this event, and big word of gratitude to the organizers for the invitation, for the possibility to have this live conversation with you. And also, I'd like to take the possibility and inform you that the court system of Ukraine, despite all the difficulties, continues to operate effectively. And based on the statistics, around 2022, we've seen a slight reduction of criminal cases being submitted for the court hearings. This is because a lot of the citizens of Ukraine were forced to leave their houses, to leave Ukraine for seeking refuge in other countries. Still, the system continued to operate, and over the first 6 months of 2023, the dynamics of cases hearing in the courts is almost the pre-war stage. It's minus 70%. We can have a different assessment of things, but these figures, they indicate a very important aspect that our country has changed so much that in spite of the current events, in spite of the aggression, our citizens, they apply to court for the protection of their rights. They're not solving any complaints or any issues in between of them, but they go to court. Another mission of the Ukrainian court system is to hold those guilty to account. And there's already over 100,000 of cases that are currently subject to investigation. Those who understand the legal system of Ukraine, they know that the courts, when they start court hearing, they offer court monitoring and court control. They accompany the investigation process, but over that period of time, over 1,200 proceedings on the crimes against humanity, global peace and order. The cases were submitted for court hearing. We've considered over 1,000 of them. There's already the hearings that were further appealed in the cessation. But if we say that the court system is working, then why do we need a special tribunal? First of all, 99.9% of the hearings shall be considered by the national court system. We were preparing for this over the period of this open conflict, but we understand that in order to bring justice, complete and utter justice, we need the support of the international community. Now, what's the situation? On the 24th of February 2022, Russia has started a full-scale aggression, the most devastating conflict on the territory of Ukraine after the Second World War. What was the reasons for this conflict? Should we analyze those of the reasons that we could consider logical or sound? There is no reasons like that, even though the Russian propagandists, they're not hiding their true intentions, and they're saying that we are fighting, we are having the war against the collective West, against NATO, and against the whole progressive international community. And what are they not happy with? They're not happy with democracy. They're not happy with the supremacy of law, with the protection of human rights. What methods are used for the war from the very first day, in spite of the occupation of the territory of Ukraine? The whole of Ukraine was under heavy shelling, with the use of sophisticated and powerful weaponry. And this is something we have until current days. Just look at how many nuclear blackmail incidents we had, or intimidation with terrorist attacks on Zaporizhzhia nuclear power plant. Should we remember the Echo site at Kakhovka hydropower plant? It would be clear that the situation we have will impact the whole world, and it will impact also the environment of Ukraine and Europe. We have to understand that if this situation won't be assessed from the standpoint of the international law, then we'll have doubts in the effectiveness of the legal mechanisms available and the international legal institutions as well. Therefore, raising the issue of the special tribunal, I would like to say that we're doing that by acting in the interests of the whole world. There's another component yet to mention. In a more pragmatic manner, we understand that by considering the cases within the national jurisdiction system, those individuals who took decisions to start the war, they won't be subject to the our jurisdiction. Now, those who are dealing with the criminal proceedings and those who understand that there has to be justice for the deeds committed, they understand that any punishment in the criminal domain is designed not only to punish, even though the punishment and the material responsibility of the aggressor state are responsible. We also know that any case law, any accountability, they lead to a further court practice preventing cases like that in the future. Therefore, it would be logic. It was a logical decision made by the president of Ukraine, and Andrii Alexandrovich has already mentioned that this idea was something we got in the first weeks of the war. I think in the beginning of April there was a large discussion on this matter, and we were discussing how we could bring this to the attention, and therefore we've called upon the international community on the need to establish a special tribunal.
And I'm grateful to 38 countries all around the globe who supported the idea. I'm so grateful to the working group established, and in fact they already are thinking and trying to understand what the modality should be for us. Regarding the modality, the models that are offered, so it's obvious that this event, its purpose is to help us all hear each other, get all the pros and cons, and maybe to change some beliefs or slightly transform certain beliefs and ideas regarding that. Personally, I have a certain vision, my personal vision I do have, and I agree with that opinion that this should be exclusively an international tribunal. Because any hybrid combined modality, yes, we can see that we will have some practical problems. There are some practical concerns for us to implement that modality, but what model will be taken? Regardless of what that model will be, we will join the discussion, we will support it. I do want us all to have a very productive event, and I really want us all in the evening to have a more clear vision in this context. Thank you. Thank you, colleagues. Thank you so much, Stanislav. Let us not forget that the aggressor state is having so many operations and initiatives to discredit the tribunal concept itself. We notice that every day, we observe that every day, how tricky they are. They're trying to sow the seeds of doubt with European lobbies, American lobbies. They are trying to generate these doubts for our key allies. So many rumors and fears that will not be able to fight the functional immunity. But okay, guys, just give me an example of any country in the world, even the African country, in all the in what constitution there is a direct right for president to commit crime of aggression against other country, to annex the territories, or to commit the genocide crime? There's nowhere. There's no single constitution that allows that, and the aggressor states are doing that everywhere. Our task is to mobilize the civilized world at the largest extent, because the historical period that we are living today, and these horrible consequences of the crime of aggression, which leads to economic crisis, food security crisis, we should just avoid that. Thank you, Stanislav, for your report. We want to get something from our online guests, and I pass the floor to Director of International Courts and Tribunal Center, University College of London, Mr. Philip, please. Philip Sands.
Good morning, everybody from France. I'm very sorry that I can't be with you. The first thing to say is absolute solidarity with the conference and with all of Ukraine's efforts at these difficult times. This conflict has now gone on for more than 540 days. Very soon, when it began, Ukraine put the subject of justice, the rule of law, international criminal obligations at the heart of its effort to protect itself, to protect its people, and to go forward in a way that is supportive of the international rule of law. I totally support that effort. I support the efforts that are going on in the Ukrainian courts and at the International Criminal Court in relation to 3 international crimes: war crimes, crimes against humanity, and we know that in Ukraine the issue of genocide is also very large, and there are proceedings underway there at the International Court of Justice. There is, of course, a 4th international crime, which was the principal crime in the famous Nuremberg trial. It was then called crimes against peace, and it became, over time, crime of aggression, the waging of a manifestly illegal war. As many of you know, the International Criminal Court does not have jurisdiction over the crime of aggression. And yet from the outset, for many of us, it was the singular and most important of all the crimes, because without the decision to wage this war in February 2022, the other crimes would not have been perpetrated. So it struck me and many others of absolute paramount importance that the crime of aggression be put on the international agenda, and I salute the efforts of President Zelensky and Foreign Minister Kuleba in moving very fast to do that. Indeed, there's been a lot of progress over 18 months. It may surprise a lot of the attendees here to know that after the proceedings at Nuremberg, which completed in 1946, the crime of aggression was effectively extinguished from the international agenda. There was a passage of more than 75 years. And the discussions now in relation to this aggression against Ukraine mark the first time that we have international developments on the crime of aggression. Aggression was not part of the Yugoslav Tribunal, it was not part of the Rwanda Tribunal. It's the first time since the 1940s that this issue is on the international agenda. And that's a very, very significant development. And those developments include the creation of a center for the prosecution of the crime of aggression, now up and running in The Hague, and broad support from many countries, not yet though in the global south, for the creation of a special criminal tribunal on the crime of aggression. However, as we know, a significant difference of view between two groups of countries. There is one group, led by Ukraine, which is committed to a full special criminal tribunal, established under international law, which would deal fully with all aspects of the crime of aggression, including the matter of immunities. There is another group of countries, probably a smaller group, but a powerful group, including France, the United Kingdom, the United States, and Germany, who are opposed to a full international criminal tribunal. Instead, what they want is what they call a hybrid tribunal, an internationalized tribunal, which is essentially a glorified version of a Ukrainian tribunal that would be based in The Hague. For reasons that we all know, that we have discussed for many months, I'm strongly opposed to that model, which strikes me as a second-tier development. If there is going to be a special criminal tribunal, and I strongly support the idea of a special criminal tribunal, it needs to be a full international criminal tribunal with full powers established under international law, for the simple reason that I think any lesser institution will be deprived of full legitimacy and full effect. We don't know what will pass in the coming weeks and months in terms of bridging that gap between the two models. We know in life that there are unexpected developments which cause things to change. We know that Ukraine is engaged currently in a very active effort to persuade those four countries and some others that are around those four countries to join in what President Zelensky has rightly called for, a full international tribunal. And those conversations will continue, although I think in the eyes of many there is some sort of a deadlock right now. But deadlocks exist to get broken. I and others who are working very closely with the wonderful team around President Zelensky who are dealing with this issue of the crime of aggression will continue in our efforts to engage with those countries. There are private discussions, there are slightly more public discussions, to get them to change their direction. We have to call a spade a spade. We know why those countries worry about the creation of a full international criminal tribunal. They worry because if you create a full international criminal tribunal on the crime of aggression today, in relation to one permanent member of the Security Council, the possibility exists of creating such a tribunal tomorrow in relation to another permanent member of the Security Council. That's a political objection. It's not a legal objection. It's not a principled objection. It's an objection based, if you like, on self-protection. And to my view, it is not a justification for avoiding the creation of a proper international criminal tribunal on the crime of aggression. Why Ukraine for this effort? Because this is the very same territory, it's the very same lands in which the crime of aggression was perpetrated more than 75 years ago. Ukraine, the people of Ukraine, the lands of Ukraine know better than anyone in the world what has happened on these lands in the past. I wrote about this in my book, East-West Street. Ukraine, in a sense, its city of Lviv, a magnificent place, is the beating heart of modern international criminal justice. Lauterpacht and Lemkin, the founders of two of the four crimes that we're concerned with, found their origins at the university in the city of Lviv. And very simply put, if we don't deal with the crime of aggression now in relation to what's going on in Ukraine in 2022, 2023, 2024, we might as well give up on the crime of aggression. If this is not going to be addressed by a proper international criminal tribunal, I think it's very clear that the crime of aggression will wither on its vine and disappear. I don't want that to happen. Many of the people I'm working with who are on this panel today don't want it to happen. I know President Zelensky and Foreign Minister Kuleba don't want it to happen, and they can count on my and our absolutely committed support in the weeks and months going forward to make this happen. There will be a compromise, there will be a way of sorting this out. We just have to keep our heads down and carry on working. Thank you so much for for the invitation to be with you this morning.
Thank you, Philip, and much appreciate for your support in us. Thank you very much.
Colleagues, definitely. I do believe that definitely it will happen, so that for us to tackle such things as crime of aggression in global dimension, we will definitely have this standing tribunal established, or whatever mechanism is to punish the crimes against aggression, the crimes of aggression, excuse me. I just have to state it, the doctrine of international law sometimes is a hostage of global politics, of geopolitics, you know? And sometimes it happens that some of our partners, they articulate concerns. They articulate concerns that it will create a precedent for them, because the countries which have impact on global security architecture, the key players, they have various military campaigns and operations. We have to talk about it, and missions. But we should not have any fear when we discuss it, but it's not for us to keep silence or to suspend the response to crime of aggression against our country, because this is so obvious that it's committed against Ukraine right now, that any delays and any suspension, it definitely can impact negatively all the world. We have to be more determined, more confident that we will be able to tackle all the problems, all the legal concerns and restrictions. For that mechanism to be established, for that solution to be capable of at least physically isolating the people who committed the crimes of aggression, to isolate them from all the civilized world. We are sober. We understand that if we have the tribunal, we may not be able to ensure the physical presence of Putin there today. We won't. But if we limit the geography of his movements, just for minimize it a couple of countries, this is an effective solution. That is, or effective consequence for that tribunal to start functioning, or in near future. Such an isolation, political, legal isolation, it reaches the goal. It makes a person, a leader of the country, an aggressor, internationally recognized aggressor and criminal. I pass the floor to the head of the Center for Civil Liberties, Nobel Peace Prize Winner 2022, Ms. Oleksandra Matviychuk, please. Thank you. So, good afternoon, ladies and gentlemen, and I'd like to start my speech by mentioning the following. On August 21st, 2013, 10 years ago, Syrian government used chemical weapons against peaceful residents of Damascus outskirts. Approximately 1,700 people, many children, suffered from that. Before that, the international community said that the use of chemical weapon is a red line, what they said. And if Syrian government uses it against civilians, the government shall get imminent response and punishment. But when that happened, the responsibility was sacrificed. Sacrificed for the guarantees to Russia and the promises to Assad regime to join the convention against chemical weapon and fully destroy all the stock within the territory of the country. What happened? The following happened. Nobody was punished, nobody was held liable for it, and the red line was crossed. But nothing happened out of all was promised. In 2017, when Russia, using the veto right in the UNSC, they blocked the extending one of the treaties, this commission, as we call it, presented in the report what they did, 4 cases, minimum 4 cases, when Syrian government, after 2013, when Syrian government was using the chemical weapons against civilians. So why I start my speech with that? Because this is something we can learn from. It tells us that if we put the red line elsewhere, okay, so we have no right to allow to cross it because the unpunished evil is growing. So this aggressive war that was started, this is the red line that was put by the Nuremberg Tribunal, and it's a result of the World War II experience, horrible experience. So the task is not just for Ukraine; it's the task for the whole world to make Putin and the top political and military leaders of Russian Federation to be held liable for it. The topic of our panel is related to modality, so I'd like to say the following. First thing, we have to identify the goal. Establishing the tribunal, it must be a pragmatic step, not just emotional response, hysterical response, Russian aggression. It must be capable. This tribunal must be capable of holding the perpetrators liable, those who are responsible for the crime of aggression, and to hold them liable. So, primarily it's Putin, of course. And this will be an indicator. If the idea of the tribunal, if the concept itself is just an empty talk, empty chat on the international law importance, or this is a fully functional political solution. So we understand that establishment of the tribunal, it will not take away all the political restrictions. Nobody will make Russian leaders to cooperate with the tribunal, of course. But the legal foundation of the tribunal should be solid enough as it possible, as solid as it possible. To have this maximum effectiveness, the tribunal has to get this territorial and personal jurisdiction. But physical actions which comprise the crime of aggression, we speak of the planning, we speak of preparation, initiation, and the performance itself, it is committed beyond the territory of Ukraine. But it's obvious for all of us that it has a huge impact on us, on Ukrainians, on Ukrainian territory. So nobody is doubting that Ukraine has the legitimacy to punish for these actions. Ukraine principally agrees to pass this territorial jurisdiction to the tribunal. So, from the standpoint of territorial jurisdiction, regardless of the format, of modality of the tribunal, this activity will be legitimate. But with personal jurisdiction, we have problems, and it was mentioned by the speakers.
Because the tribunal will have to face individual immunities of Russian officials. The International UN Court has recognized that the personal immunity of the president of the country does not matter when we talk about the International Court. Of course, you can debate a lot about the International Court, but Ukraine has no time for those debates to take place. But still, you don't need to be a lawyer to understand that the International Tribunal is something that is established outside of national jurisdictions. Therefore, the model of the internationalized tribunal, meaning there's a national court plus the international judges, this is something that is legally unacceptable. But why the model of internationalized tribunal is something that cannot be applied for our situation? We've heard today that in order to engage international judges, we do need to amend the constitution, which is impossible during the martial law period. So the establishment of the tribunal, in this case, would be delayed until an uncertain period of time when Russian aggression will expire itself. So here's the question, whether this idea will be supported by the countries that are offering them now, or the accountability would be sacrificed once again to the appeasement. Therefore, there's no other legally guaranteed model except for the establishment of a special tribunal outside of Ukrainian jurisdiction. It has to be meant international. if that tribunal could not be established due to the resolution of the UN Security Council because of Russia being member of that, then we need to work on the establishment of this tribunal based on the decision of the General Assembly of the Council of Europe. There's always an option with interstate agreements, as well as this Nuremberg tribunal that I've mentioned in the beginning. This is the first ever international tribunal that was based on this grounds. As a lawyer that believes in the international law and the international mechanism, I hope that this time the crossing of the red lines will not be left unpunishable, and the international organizations, including their members, will take historic responsibility, because the unpunished evil always growing, and if Putin and his surrounding will not be held accountable, then it's only a matter of time when they will select the next country for their aggression. Thank you. Oh, thank you, Oleksandra. You know, the most recent working groups of the coordination group that took place in Warsaw, well, during that group we had a very interesting debate with our colleagues from US, UK, France and Germany. This is the group of the skeptic countries that insist on the hybrid form of tribunal as part of the Ukrainian court system. I agree with Oleksandra, and I told already that this is an unacceptable model for Ukraine, but this word internationalized, it could not only provide for the establishment of the tribunal as part of the Ukrainian court system. There's other options in the air, because we would still need to reach a compromise, and the faster we do that, the faster we'll have this compromise for all the interested parties. The faster we'll start the establishment of the model. Now there's compromise. It's just kind of an insight for you. That was the establishment of the tribunal as part of the court system of the other country, European or any other country which has a stable and developed system of law which is authoritative enough. And then after the establishment of this tribunal, there would be a vote in the General Assembly of the UN in support of the establishment of this tribunal in certain country which is not Ukraine. That's a sort of an announcement, because we'll have a whole day of the conference. There will be a lot of scientists and other experts participating in the discussion. And let me pass the floor to the director of the Institute of Law, International Peace and Security, to Klaus Klaas. He's with us online. So Klaus, please. Once again, the floor is given to Klaus Kraus, the Professor of International Law and Criminal Law. We have Klaus with us online. Okay, in order to save some time when Klaus will join us, we'll pass him the floor later on. At this point, I'd like to pass the floor to the permanent representative of the Republic of Estonia to the United Nations, to Rein Tamsar.
You can hear me?
Yes, we hear you.
Great. Yeah. No, thank you very much for your kind invitation, which of course I take as a recognition of my country's position, as well as my own humble efforts in New York in advocating for the establishment of a special international tribunal for the crime of aggression against Ukraine. I'm honored to be part of this important discussion, and I regret that I can't be with you in Kiev. Let me maybe start with a historic perspective and national context. The lasting peace after the Second World War was not just at all for Estonia and for numerous other countries, because for us, a decades-long brutal Soviet occupation, mass executions, deportations, colonization with forced Russification followed. So Russia's aggression against Ukraine, in my view, is a direct result of atrocity crimes committed by the Soviet Union before, during, and after Second World War that went unpunished. There was never a Nuremberg tribunal for communist ideology or Soviet totalitarian crimes. So impunity in the past always leads to new crimes, unfortunately. So we need to end this vicious circle, and the new Russian aggression actually opened up in a tragic way, but a window of opportunity to do so. Let me remind you that what is the main goal of the Russian full-fledged aggression against Ukraine? It is very much the same still, to exterminate Ukrainian nation and to raise a sovereign state of Ukraine from the map. Kremlin is still obsessed with swallowing Ukraine piece by piece and with the restoration of its former imperial grandeur. This aggression is therefore not a mistake or miscalculation, but a conscious and rational decision by Kremlin. It also seems a rather logical step after we completely failed to react decisively to Russia's war against Georgia, to the annexation of Crimea, and blocked Ukraine's NATO membership in Bucharest. So our indecisiveness today, our slowness, and the paralyzing fear of escalation, I would claim that are still providing Putin's regime with oxygen needed to continue this deadly war. So our fear of establishment of the International Tribunal falls into the same category. The fact is that Kremlin's neo-imperial and neo-colonial behavioral pattern of actions is blatantly violating the core principles of the UN Charter. This has been actually affirmed by the UN General Assembly several times now, and crime of aggression is a concern of international community as a whole, not just of Ukraine or Europe or Estonia, because this war has global consequences, and it goes against the international legal order with the UN at its core. So we should act collectively to preserve the authority and relevance of the UN Charter. Otherwise, I'm afraid, the Herbacean world would be quick to be reinstated. The crime of aggression, as it has been mentioned several times today, is a leadership crime. So we should not allow Putin and his henchmen to hide in a judicial loophole, because the ICC does not have jurisdiction, and the UN Security Council will never refer this case to the ICC because of Russia's veto. That is exactly why neither a hybrid nor an internationalized national model would ever work. Why establish a hybrid tribunal that will never be able to overcome immunities and therefore never be able to actually bring real justice? We should actually do both. Work to expand the ICC jurisdiction in the long run and establish a special tribunal for the crime of aggression through the UN General Assembly as soon as we can, because Ukrainian people are dying as we speak here today at the orders of a Kremlin's top man. We need to send the strongest possible political signal that the crime of aggression will never pay off. This would also serve, actually, as a very useful and credible deterrence against all other potential aggressors. And Ukrainians are indeed paying in heavy blood for our delayed decision to establish a tribunal that can actually try the real culprits of the aggression. The tribunal should not be taken a hostage of the empty hope that genuine negotiations with a war criminal obsessed with Ukraine would ever be a realistic possibility, or possibility that would not come at the expense of Ukraine. And besides, as we all know very well, the hybrid tribunal simply cannot be established according to the current Ukrainian constitution, which cannot be amended during the war. Some claim that states should not move forward because it will be difficult to gather enough votes at the General Assembly. To remind, we need 2/3 of the votes of countries present and voting at the General Assembly. it's doable, for sure. And after all, why would a hybrid model ever get more votes than an international model? This makes, frankly, no sense to me. And let me assure you that in my work and in my private conversations and during our numerous information briefings in New York for the wider UN membership, there has been no straightforward rejection of the idea of an international tribunal. To the contrary, when it comes to accountability, in order to preserve the current legal order with the UN and the Charter at its core, I would say countries have been rather supportive. In addition, when talking about the hybrid, keep in mind that it is really highly likely that Russia will try to establish a replica tribunals in response to the hybrid model and argue that a similar tribunal would need to be established for Iraq, for Libya, for Afghanistan, etc. This is just another reason to go through the General Assembly, as only the UN General Assembly would provide sufficient international legitimacy and would make the International Tribunal immune against the Russian propaganda and hybrid actions. And finally, I'm profoundly convinced that a tribunal based on an agreement between Ukraine and the UN Secretary General, endorsed by the General Assembly, would be the right thing to do from a legal, from moral, and from political point of view. So the only thing is missing is actually a political will. So I believe that we still can make sure that justice will be assured and the international law will prevail. Maybe sending a letter to the UN Secretary General requesting the establishment of a international tribunal can create the much needed new momentum in New York. And this would maybe also help our closest allies and partners to find the political will to support holding accountable the real masterminds of the Russian aggression against Ukraine. I thank you.
Thank you very much, Rain. Друзі, я хочу особливо підкреслити.
I would like to offer words of gratitude to Estonia from the first days of the aggression. I really remember that. It was kind of the 2nd or the 3rd of March when we started advocating the idea of the establishment of the tribunal to the president. Estonia was one of the first countries to extend us the hand of support. And they also supported us in establishing the special tribunal on the crime of aggression. Let me pass the floor to the Barrister, which is specializing on international criminal law and human rights, the author of Constitution of the People and How to Achieve It. So, let's pass the floor to Abraham Aarif, please.
I'm really honored to be here and to talk about the issue of aggression, where we had the principal, of course, target when it came to the latest invasion by Russia of Ukraine. I would like to use the few minutes that I have to make 3 short points on the choice of the model. First, to be clear about what we understand when we talk about a hybrid model. Second, be clear that the preference for a hybrid model being advanced by the larger states is a purely politically expedient preference to limit the precedent value of a special tribunal and to preserve the personal immunities of the Troika. And then third, to reaffirm that the most workable, legally speaking and practically speaking, is a strictly international tribunal and one that recognizes critically Ukraine's agency and Ukraine's actual preference and help fulfill what we've heard already, the international community's collective obligation in enforcing the prohibition on the use of force and the prohibition on colonial conquest and all that entails. In relation to my first point, as we know, the creation of the tribunal is no longer academic. The tribunal will be created, but the question is when and how. And definitions, when it comes to the matter of how, are critical. Now, we have to accept that there is a small community of international lawyers and scholars who are advocating for a hybrid or an internationalized model. But what do they exactly mean when they talk about a hybrid model is a highly internationalized tribunal? What does that mean? Well, first, a highly internationalized hybrid model would be set up by an international agreement, either with the UN Secretary General and Ukraine, following a recommendation by the UN General Assembly, or through a regional organization such as the Council of Europe or the EU. Second, it would have reference to international law. And third, it would have very significant international features, such as international prosecutors, international judges, and be located in an international city such as The Hague. Now, almost universally, these scholars advocating for a hybrid model expect very few features that would characterize the tribunal as domestic. And of course, the rationale for that is very obvious, but principal among them is the disapplication of personal immunities for serving heads of state, heads of government, and foreign ministers in Russia and Belarus, and also a model that would ensure the independence, integrity, and impartiality of a tribunal, and thereby giving it greater legitimacy. But we must be clear that the public preference expressed by some of the big states, including those in the G7, does not envisage that model of hybrid. They likely envisage a Ukrainian domestic court based in The Hague with as few international features as possible. Why is that the case? That brings me to my second point. The preference by the major powers for a largely domesticated hybrid tribunal is for two erroneous political reasons, and bluntly relates to the risk of prosecution of their senior leaders one day for aggression. The first erroneous belief is that a largely domestic aggression tribunal based in The Hague will somehow diminish its precedent value and preserve the idea that only the UN Security Council is authorized to create international courts, tribunals. We know that both of those are false. The International Criminal Court itself is a treaty-based organization created outside the auspices of the UN Security Council. The extraordinary chambers in the courts of Cambodia was created upon the recommendation by the UN General Assembly. The Special Court for Sierra Leone was created under Chapter 6 of the Charter, rather than the UN Security Council's authority under Chapter 7 for international peace and security. In addition to that, we also have regional tribunal precedents, such as the African Union, which created the extraordinary chambers in Senegal, which prosecuted the former Chadian president, who was obviously not from Senegal itself. The second political reason is to ensure that a future tribunal would preserve the personal immunities of serving heads of state, heads of government, and foreign ministers. Again, this stems from an incorrect belief that only the UN Security Council can disapply personal immunities. We know that it is not the case given the jurisprudence of the International Court of Justice, the International Criminal Court, and the Special Court for Sierra Leone, which all have said that immunities can and should be disapplied for atrocity crimes being tried before an international court or tribunal. It follows, therefore, that there is a desire to make a future tribunal as least international as possible. What is the practical result of that? The practical result of a domesticated hybrid tribunal is one, postponing and possibly denying completely altogether the prospects of accountability for Putin, for Lukashenko, for Lavrov, and so forth. Second, delaying the establishment of the tribunal for several years, given the changes required to the Ukrainian constitution. And third, and critically, denying Ukraine international legitimacy in its anti-imperial struggle against Russian colonial domination, and even, I dare to say, the prospect of gaslighting Ukraine, as some have suggested by some states, that Ukraine can show leadership through creating a hybrid model. Now, Ukraine has already showed leadership. It has expressed its own preference. And in fact, Ukraine, as we know itself, can and has prosecuted the crime of aggression domestically. But that is not enough in order to disapply relevant immunities. Which brings me to my final point. Many states backing a special tribunal are those that were specially responsible for the current selectivity of the International Criminal Court's framework on aggression, which means that the International Criminal Court cannot try this crime. Yet those states have accepted that the International Criminal Court can go after the Troika in Russia, even without a UN Security Council resolution. So why not permit the same for a future special tribunal? And if not, why not remove the jurisdictional hurdles that stops the International Criminal Court from prosecuting this crime? There are no good legal reasons that have been advanced. And as such, I suggest that a strictly international tribunal, either through the UN General Assembly or through the agreement of many states through a multilateral treaty, is the safest route to an effectively functioning tribunal, reaching the very top table in Russia and Belarus, and importantly, being seen, powerfully seen, to reach them at the behest of the international community and not just Ukraine. As we've been reminded by some of the other speakers, this is a conflict between two sovereign, independent states. Every single hybrid that has been created has concerned non-international armed conflicts or atrocity crimes within states. Ukraine is exceptional in this regard. Therefore, a strictly international tribunal would signal the disregard in which aggressor states are held by the international community. It would ensure an independent and impartial tribunal. It would encourage, contrary to popular belief, the global south and the marginalized regions to join this effort where it is internationalized and international. And it would genuinely signal a long-term commitment to Ukraine's and its neighbors' call to be free of imperial conquest. Thank you very much.
Thank you. Thank you, Aarif, for a very informative speech, informative report. A lawyer is a lawyer. It's very good. Our technical team informed us that the Klaus Kress is already online, yes? I'm very glad to introduce to you the professor and director of Institute of International Peace and Security Law, University of Cologne, Klaus Kress. Please welcome.
Thank you very much. Is it possible to hear me clearly?
Yes, we hear you very well.
Perfect. Thank you very much. It's a great pleasure and privilege to join you for this important occasion, and a particular pleasure to come in after the speech by Aarif that we have just heard, which I can only wholeheartedly endorse in all its essential parts, and which makes it not that easy to add many meaningful and core issues, because he has touched upon them so eloquently. But still, let me perhaps use my limited time to emphasize a few points. And first of all, I would like to take this opportunity to acknowledge progress. Let me emphasize the positive development that we have seen over the past 1.5 years. When it started, when Russia's illegal use of force escalated to a full-fledged war of aggression against Ukraine, there was surprisingly little talk about the crime of aggression. all the other crimes were at the forefront very early, but there was silence for a couple of months widespread silence with regard to the crime of aggression, with the exception of Ukraine, who then very early on made it clear that for this state, the immediate victim of this outrageous aggression, important as prosecutions, investigations, prosecutions for the other atrocity crimes are, there would be something fundamentally important lacking without the crime of aggression. And the reasons for this have been spelled out, have been made clear to the world public on repeated occasions, and there is no need to repeat them here in all detail. It is now, I think, clear and much better understood that only if investigations and prosecutions extend to the crime of aggression the entire dimension of the injustice, of the unlawfulness that we are painfully witnessing day after day, can be brought to international light as it should be. And therefore, one should see, and I'm deeply convinced about this, one should not see all those endeavors about the establishment of a special tribunal for the crime of aggression as merely being supportive of Ukraine's national interest. There is all reason in the world to support Ukraine with respect to their immediate national interests as a victim of an outrageous aggression. But the matter goes far beyond this, and actually we should be grateful to Ukraine to have made the point, a point which is far beyond Ukraine's interest. It's in the interest of the international community as a whole that the crime of aggression enters into the picture. And it should be of interest to all states in Europe, beyond Ukraine, but also beyond Europe, to each and every single state, and more importantly, the militarily less powerful states in many world regions, that this fundamental assault on the prohibition of the use of force, a cornerstone of the international legal order, is met adequately in terms of international accountability, and that must include investigations for the crime of aggression. Now, on the question of the format on which Aarif has just spoken before me so eloquently, let's make it clear at the outset that there is no inherently bad or wrong decision here between the two formats. Also, a truly internationalized Ukrainian tribunal could serve a useful purpose. It is not wrong, it is not a bad solution, but we are here confronted with a choice: what's the best solution available? And also, what's the most practicable solution available? And I have heard, and we have all heard, one very important explanation in favor of a not strictly international tribunal, which was to say establishing an internationalized Ukrainian tribunal would be the clearest way to establish the accountability mechanism that we need. And I think we have to acknowledge honestly, this is simply not true. And it is not true most immediately for the very simple reason that establishing such a tribunal poses for Ukraine, under the current circumstances, given its constitutional legal situation, given the existence of martial law, it poses a huge, an immense challenge, politically and also legally. And in that sense, it is simply misleading to say that this would be the clearest and the most practical way. Quite to the contrary, it seems that we are very regrettably, after all this progress that has been achieved over the last month, in somewhat of a deadlock, not moving forward with the speed that is necessary, and that has to do with those challenges. And that brings us to the question whether there are really compelling arguments, legal, politically, against the establishment of a truly international tribunal. And we have heard the arguments repeated over times on numerous occasions. And so many international lawyers have responded repeatedly to them, and we have heard Aarif speaking a minute ago, that none of those arguments is compelling. And I will not go into them now one by one. And so the core message remains. It has by now been acknowledged by almost all who have spoken about the subject, lawyers and politicians, that it is in the interest of the international community as a whole to ensure investigation and prosecution also for the crime of aggression. There can be no doubt that the most powerful way to convey this message would be through the establishment of an international tribunal. And if we consider that in addition, at this moment in time, establishing a Ukrainian internationalized tribunal is facing those serious challenges in the Ukrainian legal constitutional order that we are facing, then it is really difficult to see why at least not the most genuine and principled attempt possible is being made to make the establishment of an international tribunal happen. And this is the perfect occasion to reiterate the call to the international community as a whole to move forward in the most principled and also, as I see it, the most effective direction, establishing a special tribunal of an international format. Thank you, Mr. Moderator.
Thank you very much. Thank you, Klaus, for a strong message for all of us. Thank you and much appreciate for supporting us. Thank you very much. And і зараз, вибачте, я вже зараз.
I pass the floor to Jörg Polakiewicz, please. Director of Legal Advice and Public International Law, Council of Europe. So, ladies and gentlemen, for me this is such an honor.
Basic Ukrainian, but I would like to say that when I received the invitation for this conference, it was clear to me that I would have come back to this wonderful city. And I've been here first time back in 1998, participating in a conference of the Verkhovna Rada on the implementation of international law. Last time I was here was 2015, when already Russia had annexed Crimea and the signs of war were clearly visible, unfortunately not seen by all. And at the time, I was part of a team advising the Ministry of Justice on the use of derogations under Article 15 of the European Convention of Human Rights. I would never have thought I would come back under such dramatic circumstances, 1.5 years of a barbaric aggression by the Russian Federation. But at the same time, I'm so happy to be here. I think never has it been more important to discuss questions of accountability. Never before have the stakes been so high for peace, international cooperation, diplomacy to prevail over war and suffering. It's very difficult for me to add much after all these very distinguished lawyers. That's why I will just divide my intervention into two parts. I would briefly recall what the Council of Europe has already done. After all, I'm here as a representative of the Council of Europe. Although I must stress, my views are personal. I cannot commit the organization. I'm just the legal advisor. And secondly, I will try to address, maybe under a new angle, hopefully, this issue of modalities. Very briefly, for the Council of Europe, I think the Russian full-scale invasion was a watershed, or a Zeitenwende, as the German Chancellor has said. But our organization has taken immediate action. Only one day after the full-scale invasion started, on 25 February last year, the Russian Federation was suspended from membership. And a couple of weeks later, for the first time in the history of our organization, we expelled a member state on the 16th of March. Our organization has also demonstrated its rapid reaction capacity by setting up the Register of Damages, which has already started operating in The Hague as a first step towards an international compensation mechanism for the victims of the Russian aggression. Coming to the idea, back to the main topic of this panel, the special tribunal. As I said, it's very difficult to add much. The options have been clearly outlined. My main point would be, and I try to bring threads together from Kress and Andrii, Philip Sands, others. I would start by saying that, I mean, in the West, maybe we have always this idea of black and white, yin and yang, but I think these modalities should not be seen as totally mutually exclusive. I think there is a kind of fluidity among them. As it was said, an internationalized tribunal can be so much internationalized that it would clearly no longer be a Ukrainian jurisdiction. At the same time, an international tribunal can also draw on the jurisdiction of the Ukrainian criminal code, which after all is based on Nuremberg, and has the advantage that it's very similar in fact to the Russian criminal code, because both are based on the crime against peace that was recalled by Philip Sands also. So I think what is important is that we need a speedy solution and a flexible solution. From a legal, the internationalized tribunal, as as was said, it can have its seat in The Hague, it can have international judges, prosecutors, personnel. Its operation could be and will certainly be supported by funding from a large group of states. And from a legal point of view, talking as a lawyer, I think it is perfectly legally feasible for Ukraine to delegate or transfer the exercise of its jurisdiction for the crime of aggression to a tribunal set up through an international agreement, which must not necessarily be multilateral. Because I would see a problem with the fully fledged international tribunal simply because of the fact that you cannot do this without parliaments. If states now want to set up a tribunal through an international agreement, a treaty, I think all of these countries will have to go through national parliamentary, rather cumbersome procedures. And it is much easier to have a setting up through a purely bilateral agreement, say between Ukraine and the Netherlands, which could then be supplemented by a web of agreements, even arrangements involving the cooperation of other states, the mutual legal assistance that will be provided. And this could be done much easily through memorandum of understanding or other more easy to be concluded executive agreements. And as I said, I also not see a problem with a rather broad definition in the Ukrainian constitution, the Ukrainian criminal code. Where there is a problem, I think we heard, first of all, by the Chief Justice, Stanislav Kravchenko, on the constitutional issues. There, I have to admit, I'm not an expert on Ukrainian constitutional law. I can only note that this prohibition, I think it has not prevented neither the transfer of criminal proceedings to a Dutch court in the case of MH17 flight, nor the establishment in 2018 of the High Anti-Corruption Court as an institution including international advisors. I'm aware this was not an international tribunal, it's clearly a Ukrainian institution. The international personnel was only advisors. But the examples nevertheless show that there is some flexibility. I think lawyers are there. My motto is always lawyers should not find a problem with every solution, but a solution to every problem. So I think we need creativity in this field, and because we have to bring together as large membership of the international community. And this is a challenge, but I'm here to help Ukraine, as are all my colleagues. Just a final word on the Council of Europe's role. I think the Council of Europe, you can be assured, stands ready to help in this respect. As also suggested by the Secretary General, the Council of Europe could support the tribunal by providing assistance, for example, in the selection and appointment of judges, the elaboration of rules of procedure, and secondment of experts. I think what is important now is, these are my concluding remarks, the wheels of justice grind slow, but grind fine. It took some 20 years or more to hold Radovan Karadzic, who was already indicted in 1995, to hold him finally criminally accountable. The former president of Chad, Hissène Habré, was sentenced to life imprisonment also more than 20 years after having committed the crimes. I think the Ukrainian people should not wait for so long. The establishment of the tribunal is a necessity. It is a matter of justice and credibility for the international community. Legal issues have been thoroughly discussed in many fora, not least in the core group, of which I've been honored to be a participant, together with legal advisors from some 40 member states and states all over the world, not only Europe, but also the European Union. I think this core group should remain the forum to discuss further these issues and find solutions. But most importantly, we must let us seize the momentum which was created by the setting up of the International Center for the Prosecution of the Crime of Aggression and the Council of Europe Register of Damage. Impunity anywhere sends the wrong signal everywhere. Thank you very much.
Thank you, Jörg. Друзі, я хочу...
Dear friends, I would like to underline the effectiveness and truly open support of the Council of Europe on the 28th and 29th of April last year, just after a month of aggression. The first two resolutions of the Council of Europe were approved. They were calling upon the establishment of a tribunal and ensuring its complete funding. The support that we are feeling from the Council of Europe is truly energizing. It's open friends, open partners.
And for his pretty Ukrainian language, please. Thank you very much. Ми йдемо далі.
And we move on. I know that you've already feel a bit tired, but this is almost the end for the first panel.
Передати слово.
I would not like to pass the floor to the prosecutor of the international tribunals on Rwanda and other tribunals, to Richard Goldstone.
Attend this most impressive gathering. I'm absolutely in complete agreement with all of the previous speakers who have really made a plea for a truly international tribunal on aggression in respect of the terrible Russian aggressive war on Ukraine. The situation is that it's a great tragedy, in my view, that it's taken the lives of many tens, if not hundreds of thousands of Ukrainians, of many tens of thousands of innocent civilians, to bring the whole question of aggression again to the forefront of international criminal law discussion. The fact is that at the meeting of the Assembly of States Parties of the International Criminal Court in Kampala some years ago, when a definition of aggression was agreed, and the Rome Statute was amended to allow, in certain circumstances, the International Criminal Court to prosecute this terrible crime of aggression. There was a lot of horse trading in Kampala, and the result was, unfortunately, as we know, that non-member states of the Rome Statute may not be prosecuted for aggression before the International Criminal Court. And of course, that's the reason that in the present situation, the chief prosecutor of the International Court, Karim Khan, is unable to bring a charge of aggression against the Russian leaders, and that has led to this whole debate on a special court in respect of aggression against Ukraine. On the bright side, and unfortunately, as I say, the Ukrainian people have paid and are paying and will pay a very heavy price for it. On the bright side, the whole question of aggression has again arisen, and there is a fairly large movement afoot in many countries around the world to again amend the Rome Statute to allow the crime of aggression to be brought in the same way as other core crimes or atrocity crimes can be brought under the Rome Statute by the International Criminal Court. There's very little, if anything, I can add to the reasons for the necessity now of a truly international criminal tribunal on aggression. The whole purpose in modern international criminal law, the whole purpose of prosecutions is to bring to justice and accountability those who are most responsible, those who are most guilty. And who are the most responsible? Who are the most guilty? It's the leaders who give the orders for these terrible crimes to be committed. And it's a great misfortune that the International Criminal Court at present is unable to bring charges of aggression against President Putin and those high officials who are conspiring with him to pursue this crime of aggression against Ukraine. So the only way to do it, it seems to me, is the only sensible way, and I agree with Professors Philippe Sands and Klaus Kress and others who have said that the optimum solution is an international criminal tribunal in partnership between the Ukraine and the General Assembly of the United Nations. The reasons for this have been given, and I think I should leave it there and express my full support for that solution. Thank you very much.
Thank you, Richard. Thank you. Друзі, я хочу запросити до...
Now, dear friends, I would like to pass the floor to the President of Global Rights Compliance, Wayne Jordash, please.
Thank you very much, and thank you to the organizers for the invitation to take part in this panel. Well, coming last, I think much has been said, and I don't want to repeat, but I agree with almost everything that's been said about the importance of an international criminal tribunal for the crime of aggression. Now, because I'm coming last, I think maybe I can better spend my time just making a few personal comments about actually the journey that I've come on in terms of my support for an international criminal tribunal. I was one of those in February and March of 2022 that Professor Kress referred to as perhaps detractors. I was firmly against the idea of a tribunal, and I'll explain why. I could see very early on that Russia's approach to the war was going to be targeting civilians, and it was clear, therefore, that Ukraine's national system was going to find it very difficult to cope. It was also very clear to me that the international system was going to find it very difficult to cope. And I'm talking about the International Criminal Court, I'm talking about regional states that prosecute or should prosecute under universal jurisdiction principles. And so my great fear of a tribunal at that time was that it would detract from the efforts to investigate and prosecute violations of international humanitarian law, crimes against humanity, potentially genocide. And we've seen this in the past with international tribunals. International tribunals are not the panacea. They are not the cure of all ills. And I want to refer to what Oleksandra said about making any tribunal functional and pragmatic and practical. It has to work, and we shouldn't lose sight of that. And we shouldn't lose sight of the fact that an international criminal tribunal or any new tribunal has the risk of sucking the legal energy and the political energy out of efforts which are already in train, judicial processes which are already under massive strain. Let me give you an example. The Special Court for Sierra Leone, a court set up which arguably is hybrid, arguably is internationalized, arguably is international, tried in the end 9 people, set out in 2001 to try 13 people, said it would be done in 3 years. 11 years later, they tried 9 accused. The thousands and thousands of suspects and perpetrators within Sierra Leone never saw any investigations and were never brought in front of a court. The Special Court for Sierra Leone, for all the good it did, and there's an argument there, sucked the energy out of the possibility of national processes for the vast majority of the perpetrators. So my instinct was, we need to focus on what we have. We need to make the ICC work. And let's remember, the ICC, an international court, over the last 20 years, it spent $1.5 billion and it's convicted 5 people of international crimes. That's why I say international courts are not the cure for all ills. They are expensive, they're slow, they sometimes work ineffectively, and they can, as I've said, suck the energy out of other judicial processes. And Ukraine is struggling with the enormity of the violations of humanitarian law. Any state would struggle with this. It doesn't matter how wealthy or how developed the legal system, it is almost impossible to investigate and prosecute this range of crimes being committed by Russia. And we need to focus on what is practical and make it work. Now, why have I changed my mind? I think I've changed my mind because essentially, and I'll go back to what we all know now is the famous quotation from Nuremberg about the crime of aggression being the accumulated evil of the whole. My organization supports the prosecution here. We have mobile justice teams and we have prosecutors and investigators, and we go out into the field with the prosecution and we review the prosecution evidence and we support them in their investigations. And it's crystal clear to me that, as I think the representative from Estonia said, This is not a crime of aggression which happened by some misinterpretation of the law. This is not like the invasion of Iraq, where there was some misguided attempt to bring democracy to Iraq, or some misinterpretation of intelligence which suggested there was weapons of mass destruction, or even, as some people argue, a war of aggression to seize the oil fields and etc. This is a war of aggression, as the patterns of crime clearly show, which was designed to subjugate millions of Ukrainians. This is not an attempt to occupy territory, it's an attempt to subjugate Ukrainians and force Ukrainians to give up their identity. War crimes, crimes against humanity, and possibly genocide are built in, they're baked into the crime of aggression. So that's the accumulated evil of the whole. And I know that I live in Ukraine, I live in Kiev, like many of you here, and I understand that every time a missile lands and kills a civilian, one of the thoughts is this a war crime? But the prevailing thought is always, this would not be happening but for the crime of aggression. And therefore, we have to push for an international criminal tribunal. We have to push for the most extensive authority. We have to push for the most extensive enforcement possibilities. But we also must, in my respectful submission, not let perfect be the enemy of good. There has to be a tribunal. There has to be a practical tribunal which can bring as many of the leaders to trial as possible. That's the challenge, practical, effective, and to integrate it within the efforts that are ongoing already to investigate and prosecute war crimes, crimes against humanity, and genocide. Thank you very much.
Thank you, Wayne. Друзі,
what Wayne has said, it supports the need for the establishment of an ecosystem, an infrastructure that would rehabilitate the international law doctrine to prevent the whole world from facing the crime of aggression. And Europe has a new center that would be collecting evidences on the crime of aggression. There's enormous case of proceedings already registered at the ICC, and if it would happen so that ICC mandate would be more affordable from the prism of aggression, we wouldn't be gathering today. But as you can see, over a year and a half, there wasn't a single proceedings on the crime of aggression registered at the ICC. So our key objective to have many debates, and as the result of these debates, to have a single idea on what should be the prevention mechanism for the future, how to hold accountable the perpetrators for current crimes, and how to prevent the future crimes. Let me pass the floor to the final speaker of our panel. That's the judge from Argentina, Franco Marcelo Fiamara, please.
I want first to thank the organizers of this event on support of Ukraine. My name is Franco Fiumara. I am criminal judge and university professor, Buenos Aires, Argentina. Through my academic career, I had published several research papers on various legal topics, specializing on the criminal prosecution of the individual responsible for the terrorist attack in Buenos Aires, in the Argentine Republic. You have been trying for more than 20 years to find a legal path to bring to justice the people behind the attacks of 1992 and 1994. In Argentina, the most serious in the justice histories of Latin America. Our justice system manages the identified civil of the perpetrators. Some of them are currently government officials of Iran, others are members of the terrorist group Hezbollah. By the way, the aggression committed by Hezbollah inside Argentina was classified as a crime against humanity. The lack of international cooperation in criminal murders, coupled with the reticence of some countries in detaining visitors with diplomatic passports, that appears on Interpol's red notice, is partially filling the international system to the detriment of the victim, who are crying out for justice and reparations. In response to this, several bills were present in the Argentine parliament to establish a hybrid procedure in order to prevent this criminal from going unpunished the alleged Russian perpetrators? The answer is yes. In order to solve or resort to comparative law and international court precedents that can be applied to our judicial system. In terms of international precedents, the will of supported, for instance, by Article 20 of Chart of the International Tribunal at Nuremberg, which reads as follows: the Tribunal shall have the right to take proceedings against a person charged with crimes set out in Article 6 in the 3 letters of the Charter in his absence or absentia, if he has not been found of the Tribunal for any reason found it necessary in the interest of justice to conduct the hearing in his absence. The argument is reinforced by the Statute of International Special Tribunal for Lebanon with Resolution 1757, Majority 2007. It was granted of Chapter 7 of the United Nations Charter, which addressed the threats to war, peace, and security. Article 22 says the following: trials in absentia, the special tribunal shall conduct trial proceedings in the absence of the accused if he or she, letter A, has expressly and in writing waived her right to be present. B, has not been handed out to the tribunal by the state authorities concerned. C, has absconded or otherwise cannot be found in all reasonable steps have been taken to secure his or her appearance before the tribunal and to inform him or her of the charges confirmed by the pre-trial judge. The national bill used a mixed formula of trial between defendants who are the present or absentia or the fall, such as when it adopted before to prosecute the terrorists of attacks de Charlie Hebdo and Super Kosher by Bulgaria, the European Union, which tried the terrorists for the attack in Burgas, in a judgment confirmed by the Supreme Court in 2023, and by Ukraine, which admitted the type of legal proceeding, example in case of Yanukovych, who fled to Russia and countered with Vladimir Putin protection, but was ultimately prosecuted and convicted in absentia in January 2019. The American continent has also as important legal instrument the Inter-American Convention Against Terrorism, adopted in 2002, entering into force in 2003. And we used the final report of the 26th United Nations Conference on Human Rights of Victims of Terrorism, which expressly recognizes the rights of the victims to have the perpetrators of a terrorist attack identified, arrested, prosecuted, and convicted. In Argentina, Artículo I-Z of current Law 207372 refers to the right of victims of terrorism. Society at large is a victim of international terrorism, has an inalienable right to justice in order to prevent impunity due to lack of action of adequate legislation or by biological impunity due to the lapse of time, and to specifically guarantee the right to truth, access to justice, and speedy trial. We can resort to these legal tools with a good track record of preventing impunity in similar cases, to be used in a hybrid court, national or international, to prosecute those who initiate this war of aggression against the Ukrainian national territory. Thank you, і слава Україна.
Героям слава. Thank you, Franco.
Thank you very much.
Thank you for your report. Thank you for your opinion. Друзі, от
So friends, we're almost over with the first panel. We will not have question-answer session. I don't want to have the hatred atmosphere just rising in the room. We all want to have some coffee. This is an introductory panel. The aim was to set the tone for the discussion. Discussion around the hottest legal issue, let's say. The legal and the global politics, the international law is a weapon itself. It's a powerful weapon. The civilized world must wake up as soon as it can, just because the doctrine of international law it's frozen. We have to defrost it. And as soon as those wake up, we will live in the civilized world finally. So I'd like to express gratitude to all of you, to the team of the MFA. I will not give the names. We're so grateful for their titanic efforts, for their wonderful job that they were doing. They were advocating and are advocating the tribunal issue so hard. The MPs team and all the group established by the presidential decree. A round of applause to them, and of course, a round of applause to our international partners and guests. Those who, despite the danger that we still have in the country and all those threats, they managed to stay with us offline and online both. And applause to them, of course. And thank you to all of us. So we have a coffee break right now. Thank you.